Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to talk about the most recent traumatic brain injury verdicts in New York, verdicts and settlements. And I took a quick look, and let me try to go through this quickly so we get to the interesting parts. And I'm going to focus on the traumatic brain injury or the TBI aspect, the head injury, as opposed to some of the other injuries. But if I see another injury that's very important in obtaining the ultimate result, then I may talk about the other injury as well. Okay, so the first case is a bicyclist that was permanently injured in a car crash. And so it was a settlement. It was in the state of New York in Nassau County. And one of the injuries that was claimed was a traumatic brain injury. Now, what happened was, now, by the way, the trial happened or the settlement happened August 8th of 2024. So just a few months ago, about 4 or 5 months ago. And so the plaintiff was 72 years old. And what happened was on July 22nd of 2020, the plaintiff, who was 72, was riding a bicycle. And this was in Nassau County on the North Shore. And he was struck in the rear by a vehicle, and he claimed neck, shoulder, wrist, and back injuries. So he sued the owner and the operator of the vehicle that hit him. And he claimed that he was riding the bicycle in the middle of his lane when the defendant driving behind him attempted to pass him and struck his bicycle, which then ejected him into the road. And the defense maintained that the plaintiff was negligent. They argued that the plaintiff was unsteady and swerved in front of the car as though he was going to make a U turn, thereby causing the accident. And so the defendant's account of the accident was also supported by the passenger in the car. And so the plaintiff was hospitalized for 3 days. He had wounds that were treated, and he was told to follow up with his physician. And it turned out he ended up having herniated discs, radiculopathy. He had atrophy of the infraspinatus tendon. So he had a bunch of different injuries. And he actually also had a scaphoid fracture of the left wrist. And, um, and he also claimed a traumatic brain injury, including post-concussion syndrome, post-traumatic headaches, dizziness, vertigo, phonophobia, blurred vision, injuries to multiple teeth, and other injuries. So he went to an orthopedic surgeon, and he was put on a course of physical therapy. And then he ended up having surgery to his neck, and that was a discectomy, a partial vertebrectomy. It was at C4, C5, and C5, C6, and it was actually a C5, C4 to 5 fusion and a C5, C6 fusion. And then he had additional physical therapy. And then he actually had to have two surgeries. The first was an arthroscopy of the shoulder, and then a second one, he had another surgery for the shoulder as well. So he's got two shoulder surgeries, a neck surgery, and he's claiming this traumatic brain injury. They don't tell you too much here in this case about the traumatic brain injury. I'm assuming that's just another one of the injuries, but maybe it's not the most important injury since he's got all these other injuries. Now, his expert in neuropsychology causally related the brain injuries to the crash and noted that the plaintiff suffers from an acquired neurologic cognitive impairment related to the traumatic brain injury. So that was he had a neuropsych that said this is caused by the crash, the traumatic brain injury. And he still continues to have headaches, forgetfulness, pain, limited range of motion. And so he sought to recover approximately $600,000 in future medical costs and $400,000 in loss of household services, plus damages for his past and future pain and suffering. And his wife filed a loss of consortium claim. And so the defendants' doctors, the IME or DME doctors, what they said was that they had doctors in orthopedic surgery, spinal surgery, and radiology. And they gave the opinion that this plaintiff's neck and shoulder injuries were pre-existing and unrelated to any trauma sustained in the accident. And the radiologist then further concluded that based on the medical imaging, this plaintiff did not sustain any traumatic brain injury as a result of this accident. And so the parties negotiated a pretrial settlement. The settlement was that the owner of the car's insurer tendered its primary policy, which provided $300,000 of coverage, and then also agreed to pay $950,000 from its excess policy, which provided $2 million of coverage. So the total settlement was $1.25 million. And so there was no trial here. It was a settlement. So, I think it's a pretty good result for Nassau County, 1.25. It's not huge. They could have gotten more, right? They could have gotten 2.3. So they left like $1 million on the table. And considering he had this fusion at C4, C5, and C5, C6, that's pretty serious, plus a traumatic brain injury, plus 2 shoulder surgeries, they probably could have gotten a little bit more. But, it's not a bad result. It's over $1 million. So let's see what the second case is. Here's a case out of Westchester County. This was a trial that went to verdict, and this was a case that happened. The trial was on May 10th, 2024. And so the plaintiff, let me see here. Okay, so it happened back in October 17th of 2018. The plaintiff, Jesus Esposito, he was 48, an accountant, a patient at Westchester Medical Center in Valhalla. A day earlier, he had been hit by a car while cycling. He was brought to Westchester Medical Center and diagnosed with a traumatic brain injury. So he recovered from the brain injury. However, he developed a deep vein thrombosis in his lower left leg. And on November 18th, about a month later, he was still in the hospital and he suffered a pulmonary embolism, and he went into cardiac arrest and died approximately 1 month later. And so his widow, acting individually and as administrator of her late husband's estate, sued Westchester Medical Center and related entities. And the lawsuit claimed that the hospital staff departed from accepted standard of care, and that this departure led to the plaintiff's death. So they sued a few doctors. And so, but at the end of the case, the doctors were dismissed by summary judgment, and the only entity really remaining in the case was Westchester Medical Center. And so the plaintiff's attorney argued that the hospital staff should have inserted an inferior vena cava filter, because that would have prevented pulmonary embolisms by trapping blood clots before they reached the heart or lungs. And then they further argued that the hospital staff missed signs of impending deep vein thrombosis, or DVT, and a pulmonary embolism. And they specifically noted that this plaintiff had repeated signs of agitation on November 18th and also had been coughing up blood for 3 weeks. And they argued that the family had been complaining about the plaintiff sweating and kicking his left leg. And these were all signs of a deep vein thrombosis and or pulmonary embolism. And the plaintiff's attorney also disputed whether the hospital staff properly used sequential decompression devices between November 11th and November 18th. Specifically, they argued that the hospital's nurse practitioner submitted an errata sheet in which she changed her testimony regarding the reason she canceled her order for these devices. So that's a major, change of testimony in the deposition. And the defense argued that this was a sudden, unpreventable pulmonary embolism and that he did not show any warning signs of the condition. Defense counsel specifically claimed that although the plaintiff was coughing up blood, this symptom was caused by the tracheal tube placement rather than a blood clot. The defendant also gave the theory that the fatal clot may have come from the plaintiff's upper extremities and not from his leg. However, per plaintiff's counsel, the defense conceded on cross-examination that there was less than 10% chance the clot came from the upper extremities. And so the injury was a pulmonary embolism, cardiac arrest. They recovered a pulse after 28 minutes, but he was declared brain dead, and he was transferred to another hospital for hospice care. And on December 23rd, he passed away, and he was survived by his wife and 2 minor children who were 7 and 10 years old at the time of his death. So really tragic, only 48 years old. And both children testified that their father used to cook, clean, pick them up from school. He also taught his daughter how to play piano. So the daughter testified that she struggles with her Spanish homework and that she would likely be fluent if her father, a native Spanish speaker, was still alive. And she added that she is sad her father will never see her wedding day. And meanwhile, the son stated that the plaintiff will never get to coach the son's soccer team. So they sought recovery for past and future loss of services, as well as past and future lost wages, lost earnings, and damages for the children's past and future loss of parental care and parental guidance. And so the jury determined that the hospital departed from accepted standards of care by failing to appropriately use sequential compression devices and by failing to appropriately monitor the plaintiff for signs of a deep vein thrombosis and pulmonary embolism. The jury concluded that these departures were substantial factors in causing the plaintiff's death. So there was actually a hung jury on the question of whether the hospital departed from accepted standards of care by not placing this inferior vena cava filter. But the amount, the jury awarded the plaintiff $23.3 million. So very substantial verdict. The way it was broken down was that the wife received $1,500,000 for the past loss of services, as well as $1,500,000 for it says maybe it's an error. It says past lost services twice, 1.5 million. But then for future loss of services for 25 years, the amount was 7.5 million. So the total plaintiff's award for the wife was 9 million, right? And then for the estate, there was 300,000 past lost wages, 4 million future lost wages for 25 years, and 4 million past loss of parental care and guidance, as well as 6 million future loss of parental care and guidance for 25 years. And so the total award for the estate was 14.3 million. So the total 14.3 plus 9 was the 23.3 million. And so the demand to settle the case was actually only 3.5 million. And so it wasn't paid. The offer was only 300,000. So this is an example of how like these insurance companies, right? They make these mistakes. They evaluate the cases wrong, and they really lowball the case. They 300,000 for someone's life like that. I guess they thought they weren't at fault, and they thought Westchester is a tough venue, but the plaintiff's attorney did a good job, and they got this $23 million verdict. We don't know if it's going to hold up on appeal. It might get reduced a bit, but it's probably going to get, even if it gets reduced, it's not going to get reduced lower than 3.5, right? So that demand of 3.5, they should have given, a substantial offer against that demand, either paid the 3.5 or paid like 3 or 3.4 or whatever, but not 300,000. That was foolish, I think, by the insurance company. And the trial took 9 days. And so the jury deliberated for 2 days, and they voted 4-2 on that inferior vena cava filter. That's why it was a hung jury, right? Because you need 5-1 or 6-0. You can't do 4-2. But they were 4-2 on the filter, but 5-1 on the other liability causation questions, and they were 6-0 on damages. It was 4 men and 2 women on the jury. The next case is a Queens County case, and this one was in April of 2024. What happened here was that on December 23rd, 2013, so this is a while ago, the plaintiff, who was 33, a housekeeper, was struck by a pickup truck, and it happened in a crosswalk in Manhattan. And the truck driver was making a left turn, and basically, so the plaintiff sued the defendant, claimed he was negligent. Plaintiff's counsel argued the traffic signal permitted entrance into the roadway, and that the defendant failed to yield the right of way. The plaintiff moved for summary judgment on liability, and that was granted. So it was a damages only trial. Now, the injury was that the plaintiff was transported to Beth Israel Medical Center. The plaintiff claimed lateral and medial meniscus tears of the right knee, along with suprapatellar effusion, chondromalacia, and synovitis, and a traumatic brain injury that allegedly caused post-concussion syndrome, headaches, and cognitive deficits. And there was also an L4, L5 herniation. So there was an arthroscopic right knee surgery, and there was physical therapy with epidural injections, and then there was a lumbar microdiscectomy in 2023. And during the exam with the life care planner, the plaintiff complained of difficulty sleeping, memory issues, dizziness episodes, and could no longer swim, run, or physically play with her children. And the life care planner concluded that the plaintiff needs future treatment, including medical monitoring, medications, diagnostic studies, therapies, and medical equipment. So the plaintiff sought recovery of past medical expenses for her hospital treatment, physical therapy, and visits with her orthopedic surgeons and neurologists. She also sought recovery of future medical expenses and damages for her past and future pain and suffering. She never returned to work after the accident and withdrew all lost earnings claims prior to trial. The defense noted gaps in treatment. Defense counsel argued that the traumatic brain injury was not caused by the accident because there was no complaints of headaches until 2 years after the crash, and it was not diagnosed with the brain injury until 6 years post-accident. The defense counsel additionally claimed that the lumbar surgery was unnecessary because it took place more than a decade after the crash. The jury determined that plaintiff sustained a significant limitation or use of a body function or system. So she got over the serious injury because there's a threshold. You have to get over the serious injury question. And the jury concluded that she sustained economic damages that exceeded the basic economic loss. And so the jury awarded $799,889.92. And plaintiff was not awarded any medical expenses for treatment related to her traumatic brain injury. And a collateral source setoff may be applied to the verdict, but a hearing has not yet been held. And so it was broken down as $5,000 for past pain and suffering, $23,800 for past medical expenses, $1,900 for past medical expenses at Beth Israel, $10,000 for future pain and suffering for 37.8 years, $35,000 for past medical expenses, $24,000 for past medical expenses at a different facility, $12,900 for past medical expenses with one specific doctor, and then $672,000 for future medical expenses for 37.8 years, and $15,000 for past medical expenses for treatment with another doctor and neurologist. So the total was $799,889.92, almost $800,000. So it's not like terrible, it's $800,000, but the amount that they got for pain and suffering was terrible. I mean, $5,000 for pain and suffering for past, and it was like 10 years ago. So they didn't really believe it, it seems like. Or maybe the jury was this type of jury that believes if you get into a car crash and you get hurt, all you're entitled to is money for your medical bills. Because they gave her $672,000 for her medical bills for 37.8 years, but they thought the injury was so small that she should only get $10,000 for future pain and suffering for nearly 40 years, right? That's not even $1,000 a year. That's like nothing. So it's kind of a weird verdict, but I guess the jurors did not believe she was hurt that much, right? Because they only gave her 15,000, but they believed that she would have medical bills related to these conditions, and then gave her money for that. So this was a 4-week trial. The jury deliberated for 2 days. The jury voted 6-0. The jury were 6 men, and this was a female plaintiff. And yeah, that's this case. Okay, let's do a few more. Let me see. Here's a case. This was a man who was actually an attorney himself. He was walking on the sidewalk, and an L-shaped piece of aluminum window capping fell from the 3rd story, and he claimed the 5-foot by 2-foot window capping struck him in the head. So he sued the property owner, he sued the manager, and then he sued the window company that installed and supplied the window. And so the court granted plaintiff's motion for summary judgment on the issue of negligence. The court held that the defendants were negligent in allowing the capping to fall and in failing to erect the sidewalk shed as required by the building code. The jury was asked to decide whether the capping actually struck the plaintiff. because I guess the defendants were saying it didn't even strike him. And according to plaintiff's counsel, an independent eyewitness claimed the window capping did strike the plaintiff in the head, and the plaintiff's counsel also noted that the window's incident report stated that the capping had hit the plaintiff. An employee of the landlord testified that the plaintiff was not struck in the head, and an employee also stated that he heard plaintiff say the capping did not hit him. And so the injury was a traumatic brain injury, concussion, and the incident also exacerbated the plaintiff's bipolar disorder. He received Botox injections, magnesium infusions, acupuncture, physical and vestibular therapy, and he additionally took migraine medication and saw a therapist for his bipolar disorder. The plaintiff treated with numerous other doctors, including an optometrist and neurologists, and the plaintiff's counsel maintained that the objective medical evidence supported the plaintiff's traumatic brain injury claim. The plaintiff's attorney argued that the plaintiff's injury could have only been caused by the falling window capping. And the plaintiff said his brain injury caused post-concussion symptoms, migraines, and cognitive deficits, along with impairments in his processing speed, attention, and focus. He claimed that his accident also led to behavioral issues, vestibular imbalance, nystagmus, and saccades. He said that these injuries made reading and computer work difficult, and he returned to work with accommodations from his employer initially, but he was eventually discharged and has been unable to find new employment. And the plaintiff's attorney argued that he's totally disabled. So they sought recovery of $100,000 in past medical expenses, $2.2 million in future medical expenses, and $8 million in past and future lost wages. And they also sought recovery of damages for pain and suffering. And plaintiff's counsel asked the jury to award $40 million. The defense argued that the window capping could not have caused these injuries since the capping did not actually hit him. And then the verdict, the jury rendered a defense verdict, meaning they gave nothing. They concluded that the plaintiff was not struck by the window capping. So it doesn't give like the specifics, but I guess, there was some kind of big issue about this window capping, whether it hit him or not. I see they had a lot of experts. They had a lot of attorneys too. Like there were 1, 2, 3, 4 defense lawyers, and there were like 1, 2, 3, 4, 5, 6 experts that the defendants used, and the plaintiffs used 1, 2, 3, 4, 5, 6, 7, 8, 9 experts. So they spent a lot of money. It was a long trial. I know the attorney for the plaintiff, they're very good attorneys, but unfortunately this one did not work, did not go their way. This was New York County, by the way, in Manhattan, New York Supreme Court, and it was April of 2024 that it happened. The plaintiff was 36 years old, and the incident happened June of 2017. So it happened a while ago, and then with respect to the trial, it was a 5-1 vote, and the demand was $8 million with a $3 million, I guess a high-low of $8 million, and then $3 million would be the low. And the offer was actually $5 million high, but $1 million low. So a high-low of 5-1. I don't know I guess they didn't take it, the high-low. They didn't take the parameters. If they took the parameters, then they would receive either the high, well, I guess they would receive the low because it was a defense verdict. But the trial took 4 weeks. The jury deliberated for half a day, and the jury vote was 5-1. Here's another case. This was a laborer who claimed vision impairment after a worksite incident. This one's in Brooklyn, Kings County. And what happened here was that the trial was in September of 2023. This was actually a settlement. And back in January of 2018, the plaintiff, who was 28, a laborer, he was removing tiles from the wall in a 3-unit condo. And he was initially hired to do cleanup work for a construction project that was almost done. But then the GC, a construction company, directed him to perform remedial demolition work in this shower tub area. So he claimed that he was working on a closed A-frame ladder when it suddenly wobbled and caused him to fall. And as he was falling, the tip of a crowbar he was using penetrated the upper portion of his eye socket. So he suffered facial fractures and brain injuries. And that's a terrible injury. And so basically, it was a labor law case under 241(6) and 240. And he claimed the A-frame ladder that was given to him was inadequate because it could not be fully opened in this shower area because it's a small area, and that this forced him to use the ladder in a closed and dangerous position. And so they talk a lot about like liability. The injury was that he was taken to the taken to the hospital by an ambulance, admitted, diagnosed with mild traumatic brain injury, encephalomalacia, intracranial hemorrhage, subarachnoid, subdural, and epidural hematomas. He was also diagnosed with comminuted fractures of the left orbital roof, left eyelid lacerations, and detached left retina and post-traumatic stress disorder. And he remained hospitalized from January or through January 19th. So it happened January 8th, and he was hospitalized until January 19th. And during his hospital stay, he had a bifrontal craniotomy surgery, a left globe exploration, a repair of his left orbital roof fracture, and repairs of the eyelid lacerations. And following discharge, he was treated with an ophthalmologist, so social workers. So he had the really, really serious injuries, and he had this brain injury expert that talked about that his traumatic brain injury makes him more likely to develop Alzheimer's and or Parkinson's disease in the future. And his ophthalmologist gave the opinion that the plaintiff will experience no improvement nor worsening of his left eye condition. And his social worker gave the opinion that the plaintiff would benefit from periodic psychotherapy. And he continues to suffer headaches, loss of visual acuity in his left eye, and the craniotomy left him with scarring. So he sought recovery of a workers' comp lien along with $78,000 in past medical expenses. He also sought recovery of damages for his past and future pain and suffering. The defense's neurologist said that the plaintiff had suffered a brain injury, but the defense's neuropsychology expert gave the opinion that the plaintiff made a good recovery and does not have any lasting cognitive deficits. The defense's ophthalmologist gave the opinion that glasses could correct the vision problems, and the defense's vocational rehabilitation expert gave the opinion that the plaintiff could return to his prior job as a laborer. So the parties negotiated a pretrial settlement. The settlement was that Lloyd's of London, which insured the landlord and the construction company, the GC, tendered its $1 million primary policy and then also the $1 million excess policy. The other excess insurer for these defendants agreed to pay $1 million from a policy that provided $4 million of coverage. And then the primary insurer for another defendant tendered $1 million, and the excess insurer agreed to pay $2 million from a policy that provided $5 million of coverage. And then the third insurer tendered $1 million primary. So the total settlement was $7 million. And this was while it was on the trial calendar in Brooklyn before they were sent out to pick a jury. So pretty good settlement, but that was a really terrible, terrible injury. Well, let's do maybe one more. Here's a case out of the Bronx, and this case was in August of 2023. This was a 44-year-old, also a worker, construction worker, also a lot of experts in the case. What happened here was that on June 28th of 2013, the plaintiff, who was 44 and a carpenter, was working at a construction site at the World Trade Center, and a piece of rebar fell and struck him in the head, and he claimed head, neck, and back injuries. He sued the property owner, which is the Port Authority of New York and New Jersey, and the GC, which was Tishman Construction, and the lawsuit alleged that the defendants failed to provide a safe workplace, negligently failed. And the lawsuit further alleged that the defendants' failure constituted a violation of the labor law. So the motion for summary judgment by the plaintiff was granted. So there was a damages only trial, right? Because it's gravity related. A rebar, which is being used in the construction, falls, and it's a falling object that hits him. So that's their fault. in terms of not maintaining a safe workplace. So then it becomes damages only. And here, the rebar cracked and damaged the plaintiff's hard hat. He felt immediate neck and head pain. On-site emergency tech examined him and referred him to a neurologist. He claimed a traumatic brain injury, post-concussion symptomology, traumatic axonal injury, and encephalomalacia. And he was diagnosed with bulges at L3, L4, L4, L5, and herniations in his neck. So the neurologist initially cleared the plaintiff to go back to work. So he returned to the job site a few days later. However, he remained under the doctor's care, and the neurologist ultimately deemed the plaintiff disabled a month after the incident. So he started seeing another neurologist and underwent a course of conservative care for his neck and back. And then he saw a spinal surgeon who performed a C4 through C6 fusion. 2 years later, the doctor performed a C6 to C7 fusion. And he also saw several doctors for his brain injury. And so the parties stipulated that the past medical expenses totaled $454,000, and then plaintiff sought recovery of this amount along with $341,000 in future medical expenses and $4,820,000 in past and future lost earnings and benefits. And he also sought damages for his past and future pain and suffering. The defense disputed the size and weight of the rebar and questioned how far it fell before striking the plaintiff. The defense also introduced surveillance videos of plaintiff riding motorcycles and mowing his lawn. Now, the defense's radiology expert gave the opinion that the plaintiff's cervical and lumbar MRIs showed no evidence of traumatic herniations or bulges, and the expert further testified that there was no signs of any traumatic brain injury. And the defendant's neuropsychology expert gave the opinion that this incident did not cause a traumatic brain injury and that any brain trauma observed by the plaintiff's neuroradiologist resulted from a prior head injury. And before closing statements, the parties negotiated a high-low stipulation. Damages could not exceed $9 million, that was the high, but they had to equal or exceed $3,444,705.76, and that was the low. So 3.45 million, let's say. So the jury determined that the subject incident was a substantial factor in causing the plaintiff's injuries, and the jury did not apportion any percentage of fault to the plaintiff. The jury awarded the plaintiff $10,010,000. After addition of the stipulated past medical expenses, the verdict totaled $10,464,705.76. But according to the high-low, the plaintiff recovered the stipulated $9 million. And so the verdict broke down as follows: $1 million for past lost earnings, $1,050,000 for future lost earnings, $3,350,000 for future pain and suffering, $3,410,000 for past pain and suffering, $1,200,000 for future medical expenses for 15 years, and so the total was $10,010,000. The judge was a judge in the Bronx who's actually the trial scheduling judge, but I guess he was doing this trial back then, because back then there was another judge who was a trial scheduling judge, so he was doing trials. He's a very nice judge. And so the demand was $13 million, the demand, and the offer was $4 million, and the trial took 12 days, and the jury deliberated for 5 hours. So yeah, so these are some of the verdicts. I mean, I'm seeing other cases. Here's another case out of Richmond, where a woman claimed an abrupt action by a bus led to a rear-end collision, and that one resulted in a 1.175 verdict, and that was also a brain injury. There's other cases. I'll try to cover a few additional cases in some other videos. But, some of the cases are defense verdicts as well. Like I'm seeing the next one in Rockland is a defense verdict. And here's one that was a decision for a court of claims for a poorly maintained intersection, and that was over $7 million. But they're all very different. And we got to get into, we got to get into the nitty gritty of each case, what it's about. But I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Please like and subscribe to our channel. Let us know what videos you want to see next. And all the best, everyone. Bye-bye.